A very good morning and warm welcome to our eminent resource person, Dr. Bharat N. Suryavanshi, respected principal, Dr. Sister Lalita Thomas, vice principals, teachers, and all the participants. It's my privilege and honor to welcome you all for the National Workshop on Intellectual Property Rights and Patents and Design Filing organized by the Department of Botany, Jyoti Nivas College in association with Rajiv Gandhi National Institute of Intellectual Property Rights Management, Ministry of Commerce and Industry, Government of India, Nagpur, under National Intellectual Property Awareness Mission is beautifully quoted in one shloka. Vidya dhanam sarvadhan pradhanam. Wealth of knowledge is the most precious wealth. We can protect our precious wealth to promote intellectual property rights, which is vital for the sustenance of our society. How to protect our creativity and innovation? For that, let us explore today's workshop. May I request Dr. Anand Raju to welcome our guest speaker and participant for today's workshop. Thank you.
At the outset, we are greatly indebted to NIPAM, that is National Intellectual Property Awareness Mission, and Rajiv Gandhi National Institute of Intellectual Property Rights, Government of India, Nagpur. On behalf of our respected principal, Dr. Sister Lalita Thomas, on behalf of the Department of Botany, Jyoti Nivas College, and on personal behalf of all the technical staff, I welcome formally our resource person, Dr. Bharat N. Suryavanshi. Thank you, sir. I also extend a warm welcome to all the teaching fraternity, research scholars, industrialists, young and vibrant students who have logged in across the nation. As always, the good things are started by lighting the lamp and seeking the blessings of the Almighty. May I now request our beloved principal to light the lamp, followed by a prayer by Dr. Ansi David.
Let us pray. All glory be to God. We thank you for all the many blessings you have showered on us. As we start this venture, grant us your wisdom and guidance as we go through this workshop which is meant to share, spread knowledge, and empower all. Bless our principal, Dr. Sister Lalita Thomas, who has lent her support. We submit our organizers and all those involved in trying to make this endeavors of ours a success. Bless our institution, students, speaker, and participants. We thank you for keeping us safe and bringing us together on this day. May your presence go with us. Amen.
Thank you, Dr. Ansiman, for invoking the blessings of the Almighty and leading us through the prayer. May I now request our respected principal and the chief patron of today's workshop, Dr. Sister Lalita Thomas, to address the gathering.
Good morning, dear friends. I'm very happy this morning to inaugurate, join with the department to welcome the speakers and the participants. Indeed, Jyotinivas College is blessed with all of you collaborating with us. We thank the collaborating institutions as we welcome our guest speakers. As already said, IPR, intellectual property right, the significance of intellectual property right today in the academic world. We believe that life is a gift. Equally, intelligence is a boon given to us. How we use this freely given intelligence during our lifetime makes us leave milestones, legendary achievements to the human race. As all of us intellectuals seriously engaged in academic activities, we have our turn to be responsible to use this opportunity of being educated, sharing knowledge, learning, teaching. We also access areas that are rare, unique, hidden, unearthed, and we also get a credit for what we discover. I would say that intelligence, intellectual property right is something that uniquely that we offer to the society. We also claim right to and own it. I wish each of us have the delight of owning our unique discoveries and that which is very significant for society in every age, and that which adds to the storehouse of knowledge, and that which actually expands the world of knowledge. God bless all of us who are engaged in this unique and useful engagement of sharing your intellectual property to others as you own it. And may our speakers enable us to, and also bring in curiosity to as to how we can actually patent our findings. May they take us through roads, paths, ways that will actually give us the motivation and encouragement to go in for serious engagement of intellectual property right. May God bless us. As our motto goes, let our light of knowledge shine. Thank you.
Thank you, sister, for that graceful and enlightening message. A quick reminder to all the participants. Participants, kindly note, this workshop is a live stream. You can ask your questions through the Q&A chat box that is shown at the right corner of your screen. Please do mention your name, and the organization. Relevant questions will be taken up by the speaker at the end of the session. That brings us to the introduction of today's resource person, Dr. Bharat N. Suryavanshi, Assistant Controller of the Patents and Design, who is working for more than 18 years in the central government under the Patent Office, Ministry of Commerce and Industry. Dr. Bharat is a postgraduate in biotechnology from Gulbarga University. He has done his PhD from Swami Ramanand Tirth, Marathwada University, Maharashtra. His area of proficiency is on bioefficacy and phytochemical studies on medicinal plants of Kinvat and Mahur forest. He has published various national and international papers. He has delivered several lectures on IPR in various parts of the country. He was deputed to Tokyo, Japan on examination and IPR issues, and he has given a landmark decision by rejecting Pfizer patent application for arthritis drug, which was filed in India in 2015. With that brief introduction, I now request our resource person, Dr. Bharat, to deliver a talk on IPR, patents, and design filing. Thank you, sir. It's over to you.
Yeah, thank you so much, sir, for introducing me. I also welcome you all on behalf of Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. I'll start with my sharing the slides.
Yes, sir. The screen is visible.
Okay.
You can go for the projection mode. Yes, sir.
Okay.
It is.
Now, sure. First of all, I introduce my office. My office is called as Office of the Control General of Patents, Designs, Trademark, and Geographical Indications. We are having different patent offices at Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS that is called Patent Information System. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management, located at Nagpur. We are having trademark offices in addition to 4. One is at Ahmedabad. Geographical Indication Office at Chennai. This is the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. This is our training center, wherein we are giving trainings to all the IP officers, professors, students of all the branch, all the fields, scientists, company managers, lawyers, even for the foreigners who are coming here to know about the Indian Patent Act. This is our website. If you are not knowing anything about the intellectual property, just log on to www.ipindia.gov.in. You will get all details about the different intellectual property rights. Again, this is an awareness program. I cannot go in detail with each IP. If you want to study patent, it takes years together. Since 20 years, I am in this field, but still I am the student of IPR. So we are conducting many programs in our organization. So we are keeping updates on our website as well as social media accounts. So please take account of Facebook and Twitter account. You can check it whenever the program's there. You can log in, join, and be perfect in the IPR. Let us see today's topic. What is intellectual property? As I have shown in my slide, something blooming in the mind, something lightning in the mind. So intellectual property is nothing but a product of mind, or we can say it's a property that arises from human intellect. How it arises? During discussion in the classroom, or you are in the lab and carrying out research and thinking on some problems. If you are alone and thinking on some problems, or anything which you are developing, that may be design, writing new books, or something, mark, anything, problems, any problems you can take. The solution for that problem is thinking from your mind and giving the solution for that. That's an intellectual property. For example, in December 2019, we heard about the coronavirus, but there was no vaccine for that, nor treatment for that. So scientists all over the world started to carry out the research on coronavirus. What is morphology of it? What is the molecular constitution of that? What is the genetic material of that? Ultimately, in the middle of 2020, we got Covaxin, Covishield. What is this? It's an intellectual property which arises from human intellect, because human thought on that problem, he carried out the research and he has given solution for that. So intellectual property is nothing but a property that arises from human intellect. Another example I'll quote here, for example, biodiesel. We know next generation may not get petrol and diesel. So we are being the scientists. It's our duty to think what is an alternative solution for that. If somebody brings solution that the process of production of biodiesel, intellectual property, or biodiesel as such is an intellectual property. So anything which outcome of our mind, that's an intellectual property. We know today many designs for the different mobiles. If somebody thinks new design, that's again intellectual property in the form of design. If somebody writes new book with a new thought, that's an intellectual property in the form of copyright. So something which is product of mind is called intellectual property. Let us see what is the background of intellectual property. Property means our mind directly goes to the tangible form of property that we say, I'm having car, gold, plot, flat, so I'm rich enough. But there is another kind of intellectual property called as intangible form of property, that is intellectual property. In that, we are having industrial property and copyright. In industrial property, we know patents, designs, trademark, and geographical indications. Let us see what is patent. Exclusive monopoly privilege are right granted by the government to the patentee for 20 years from the date of filing, or priority for commercial gain, in consideration of the full disclosure of its invention as a territorial right, not owned right. Many professors, many students comes to us, they say, we have developed a process for production of beverages. But 2 or 3 steps are very crucial, very important. I don't disclose one to you because they think that we may copy that process. But whenever you are filing the government of India, we count time from seconds to minutes. And one of the requirement of the Patent Act, that is as per section 10(4) of the Patent Act, you are supposed to disclose everything clearly with the examples. Then only you are getting the right, that is patent right, for 20 years. If you are not disclosing, then you'll get an objection from the patent office that your invention is not fully, particularly describe the invention. Simply you are making delay on your own to get a patent. Therefore, starting only, you have to write clearly to meet the requirement of section 10(4) of the Patent Act. Once you are filing an invention, then you will get the right for that. Next, let us see what is the invention and discoveries. Many people still says that I have invented microorganism, I invented metal. So it is very clearly we should know what is invention and discoveries. Discovery means finding or exploring something which is already exist in the nature, and discovery as such has no technical effect. For example, if we know the periodic table. If somebody is isolating new metal or element from the earth, it's a discovery. But the process what is employing to isolate that metal and purification, that may be new. You can file patent for that, but not the metal as such. Again, I'll quote another example here to know about the inventions and discoveries. For example, if I'm isolating bacteria from cement industry effluents or jute industry effluents or any industry effluents, like take an example of Biocon industry. The effluents are having some microorganisms, we know that. The effluents of hospitals are having some microorganisms, we know that. But somebody is taking project or simply is trying to isolate the microorganism as such, what we are isolating is a discovery. But the process what I'm employing to isolate that may be pH change, temperature change, media change, or any other parameter of the process. If you are developing new process, then you can file patent for the process of isolation of microorganism. It's unpatentable. But if you are claiming microorganism as such, it's a discovery. But genetically, if you are modifying that microorganism by using genetic engineering technology, again that is patentable, because human intervention, you are doing something with the genetic engineering and human intervention. Therefore, always, if you are doing your project and your project or your PhD thesis or MPhil thesis and invention, please go for the patent filing. If it is discovery, no need to go for the patent filing. Then what is invention? If I'm doing project for my BSc or MSc, or if I'm doing research for my MPhil or PhD, when I can say that my research work is an invention, when it qualifies for that, invention means new product or process. Many people ask us, sir, is idea patentable? Yes, but not idea as such. The idea should come in the form of product or process. Today I'm getting idea that I should produce some biological composition which can degrade the plastics, or I can modify the genetic microorganism which can eat plastics. So that's my idea, but I should do that. Then only it is patentable. Today I'm getting an idea that I should produce beverages from grapes or any other food products. It's my idea, but until unless I bring that process or in the form of product, it is not patentable. So invention means product or process. Again, it should be useful. Again, it should be novel, non-obvious, and not public knowledge before the filing date. What is non-obvious, we'll see in the next slides. Even for the paper publication, we say if my research work is not published in any other journals, then only I'll go for the publication. Same way to say that your project or your thesis and invention, it should fulfill these requirements. I've taken simple example to know about the inventions. Earlier, we are not having sharpener. Only pen. They used to sharpen the pencil by using the blades. But in the year 1822, C.A. Boucher has invented this sharpener. And he has not given the word sharpener. He has used the word tool. In engineering side, tool means something big machine. And he has written the claims tool for sharpening a pencil, writing point by saving away its own surface. How clearly he has written what is sharpener. So this is the way of writing the claims, because patent is an techno-legal document. Technology, we have to describe in terms of legal. Even in the general knowledge, when we are student, we know who has invented aeroplane, who has invented electric bulb, who has invented telephone. Many more things in general knowledge we know first time who has given. So all the technologies which first time came, they got patent for that, like Thomas Alva Edison for the bulb, A.G. Bell for the telephone. Now, can anyone tell me how and why we thought of come up to the mobile phone? This technology was in the year 1876, even though the scientists of electronic and telecommunication came up to the mobile phone. Why? What was the necessary for that? Anyone, please? As we are connected virtually, we can make it an interactive session. Anyone, please? Staff, students, professors. Why? What was the necessary they thought? Because this technology was already in the knowledge in the public domain since 1876. Anyone, please? Unmute yourself. You can answer my question. Anyone? This technology, this telephone, what was there? It's very hectic to dial, tedious to dial. 10 times I have to dial to connect my near ones or dear ones. Again, I cannot change from my cabin to my principal's cabin or my colleague's cabin because it is connected at a particular point. To overcome that, the scientists of electronic and telecommunication thought, they did research, they came with the table phone what we are using now. In that also, I can directly dial. Dialing is easy, but I cannot change again from my cabin to my principal's cabin. To overcome that, they came with the cordless phone, which we can take in hall, kitchen, drawing, only connected nearby areas. But we cannot take in the meeting, nor in the car, nor in the jail. Therefore, they again carried out the research. They came with the mobile phone in India around 2000. In that, simple Nokia of silver color was more than 5,000 rupees. Again, it was having only incoming and outgoing. Now we're having calling facility. Again we improved. You are sitting at Bengaluru, I am at Maharashtra, Nagpur. Even though we're speaking to each other, we are seeing to each other. What is this? Improvement of technology from 1870s to till today. So I want to bring your notice that always something, if you're not something, if you're doing new, only you can get the patent. Not like that. If you are doing improvement over the technology, if you are doing solving any problems, those are also patentable because improved version of that product. For example, I'll give another example for that. We know paracetamol. Everyone knows. If I consume today after breakfast at 8 o'clock, it takes 6 to 8 hours to reduce my fever. But somebody from botany or pharma come up with herbal formulation for the paracetamol, which can reduce your fever within 2 to 3 hours. Again, that's a technological improvement. You can get patent for that. So any improvement, even technology, any process, any improvement in the product is also patentable. This I want to convey you that. Don't think that getting patent is very hard. It's not at all easy. Even simple improvement in a process, products, composition can also be patentable. Again, Bluetooth. Earlier mobile, there was no Bluetooth. Now you say, I'm having Bluetooth. I'll transfer data, notes, pictures, movies through Bluetooth. What is this? It's an invention again. Geoff Hudson invented this Bluetooth. Many mistakes by the inventors. You people are doing good research, but you never go for the patent filing. You rush for the publications before the filing patent. Really, if your invention is good, please take care of when you are using in the public, or you are telling in the conferences, or in the public domain. Maintain the secrecy of your inventions, because sometimes it may be good research, you are not aware of that. And if you are thinking that your invention is not good, then wait till full research work is complete. Then you decide the value of that. You come to know the importance of that your research work. Then you can go for the patent filing. Otherwise, don't file, but don't go for the publications. Now, let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, or ornament, or composition of lines or color combination thereof applied to any article in the form of 2D or 3D or both. I have taken example as an Bajaj iron box. You can check the iron box which is in your home, different company designs. I'm having Ketan fan office. You might have having some other fan that like Crompton fan or Havells fan. The design is different. I'm using Dell computer. You might have some other computer. The design is different. So each design, if it looks beautiful, you can go for the registration. Cup set, even set of articles, you can go for the registration. That's beautiful. Sanitizing machine, new designs. If you check in the field of pharmaceuticals, ampoules, capsules, syringes, all the designs are different. You can compare this syringe with this design. The design is different. This capsule design is different from this capsule. This ampoule design is different from this ampoule. This capsule design is different from this capsule. So anything which is not in the public domain, and if you are creating that design of any kind, please go for the registration in the government of India. You will get benefit of that after licensing or selling your design. If you take in the field of textile and jewelry, curtain designs, bedsheet designs, dress designs, jewelries, bangles, earrings, all the designs you can check. I am using Timex watch. You might have having Titan watch or some other company. The design is different. Somebody use Nokia mobile, somebody Samsung, somebody Apple. Design is different. Something which is not in the market, and if you are developing new design, that's an registrable. Go for the registration, take the benefit of that. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the goods, to distinguish from the goods of the others, or it gives the authenticity goods like Reliance. We know Motorola, Tata, Bata, Parle-G, you know everything. These are the designs, are mark, are name of the how they are written, good day, which fashion written. All this comes under the brand name or trademark. It advertises goods and services, protect the innocent public from buying the goods of second-rate quality. For example, if you go to the market, you can see Adidas shoes and Chappals t-shirt. If you go to the mall, it's more than 4,000 rupees shoes. If you take in the roadside of Bengaluru or Mumbai, you can 200 because they change the spelling of that. Pond's powder, spelling is Ponds. In second-rate quality, same color of the bottle, they come with POU. We never check what exactly the spelling is registered by that company. We buy that. That is in second-rate quality. So you should know the R with encircle is an registered trademark. TM means they have applied for the trademark, but yet to get the permission from the government of India. That is called trademark registry. Once you are applying the application, it's go for the examination. Again, examination report you have to reply. Opposition, if any. Finally, that will be accepted. Therefore, you might have seen many products. Some are R with encircle, some are T. Duration is 10 years. It can be extended for every 10 years if you want to in the market. Like Tata, Bata, how long they are in the market. They are renewing every 10 years their mark. Let us see another kind of intellectual property called geographical indication. Place names used to identify the source of origin, quality, reputation, or other categories of products like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges, Kolar gold mines, Solapur territory tile. Many are the GIs have been. Tirupati laddu, many have got GI for their geographical indication. Term of protection is 10 years. It can be renewed every 10 years subject to the usage. Let us see another kind of intellectual property called copyright. Copyright is a bundle of rights, provides its holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60 years. You might have heard many singers were no more, but still they are getting royalty for that because of this term. Again, many books were written by the authors, they are no more, but still they are getting the royalty for that. How we can protect different products with the intellectual property. For example, if you are developing any device which you are using in the lab, like PCR machine, the first time those they got the patent. If you are developing any version of that, then again it's new technology. Because for example, X-ray, simple machine. Now we got CT scan machine that is patentable as an medical biotech tool or biomedical engineering field. You can patent that because it's an next version of that. So I've taken simple example, common example, know how we protect a product if it is new in the market. When Sony TV was in the market, it was very famous in the year in and around 2004 or in and around that, I guess. At that time, it was very famous for clarity and sound, especially with the two hoopers on this top of the TV for the sound. So the Sony company got patent for the remote control mechanism because on sitting on sofa set, they used to operate this technology. So they got patent for that. How it looks beautiful with the color combination and button system, that's an design. They got registered in the government of India. Sony in this fashion, mark that's called trademark, they got registered. The instruction what the company keep in the box of that, they got copyrighted, means the instruction other company will not use that. So if you are also developing any device, any process, any product, how much possible intellectual property you can protect so that other companies will not copy your product, process, design, or instruction. For example, Samsung TV. This also a company which is producing TVs, but they never copy the technology of Sony, nor mark of Sony, nor design of Sony, nor instruction, because this company already got all the protection so that plainly they can play in the market, earn in the market, and the other company will not copy. Therefore, Sony also playing in the market. Samsung also, because they both are got patent, design, trademark. Even you can take the mobile of different company, they also got patent and design. Let us see another kind of intellectual property called trade secret. What is trade secret? Something which is not disclosed to others, nor it is published, but maintained secretly by individuals or by companies, and that is called trade secret. To make you more understand, I have taken an example of Domino's Pizza. We know pizza of three kinds. Pizza, which we are getting the market in the Domino's hut. Again, the pizza which you are getting other hotel also. Pizza, which one type is prepared by a mom, sister, spouse, or anyone else in the home. The three tastes are totally different if you are really tasted. Why Domino's taste is different and fluffy? Because they're adding some trade secret which are not disclosed nor published. They are disclosed with the people who work in the kitchen of Domino's, and they have disclosed with the non-disclosure agreement. They have signed the agreement with the people who work in the kitchen. Therefore, they are maintaining secretly. Therefore, we don't know the formula of Coca-Cola. We don't know the formula of Maaza, because they are maintaining trade secret and it is maintained secretly. Again, if you check the different mobiles, if you are in your home also, 3-4 mobile, maybe with children is another kind, with parents something else, with spouse, with mother, father, all the designs, if you are using different mobile, you can check carefully. The design is different, megapixel camera is different. Again, the technology, what is the combination of hardware and software in the mobile is also different. So each got patent. Nokia, Apple, Samsung, Vivo, Reliance, all they got patent, design, trademark. So if you are also developing any technology in your own field, you can go for the protection. What can do with the IPR? Why government is making to make awareness about the IPR? How it is beneficial for the students? This slide is for the particularly for the students. If you are a science graduate, maybe BSc, BCA, CBZ, pharmacy, any science graduate, you can become a patent agent. Every year our office calls for the patent agent examination. There are two papers. One is objective, another is an descriptive. If you qualify, you'll get a patent agent number from the government of India. You can practice it. You can work with any of the belows. I'll tell you. If you are a humanity graduate or arts graduate or commerce graduate or law graduate, you can become trademark agent or copyright law agent. If you're having knowledge of IPR, you can work in the IPR policy and IPR cell of central government, state government, company, universities, colleges. Nowadays, many NGOs are there. You can work in the NGOs. Or there are many IPR firms in Bangalore, many big cities like Mumbai, Gurgaon, Delhi, Ahmedabad, Nagpur. Many firms are there in Pune. You can join with them and help the inventor to the government of India for filing the different kind of intellectual property rights. You can join to the government office if you are MS in chemistry, biotechnology, microbiology, physics, or any branch of B. There are again two papers. One is objective and the descriptive. If you qualify, you will get job in the government of India. Depend upon the vacancy and advertisement. You can also become a scientist, inventor, because already you're a scientist during the research, giving many more MPhils, PhD degrees, but you are not an inventor. To be an inventor, you have to get them patent. How we can get? Anyone can get, but you are not trying for that. When simple BSc fellow or MSc fellow or research fellow are doing the project or research, but if you want to get the degree for doing the project, they go to the library, copy the senior thesis, or mere changing the data of the thesis, they will change and submit to get a degree. Really, if you want to be an inventor, do a simple approach like this. While carry out a research or a project, identify some problems in and around you. For example, you are botanist. You can make any problem. For example, I am working on medicinal chemistry. I can do a herbal composition for dandruff. How simple? I have to study one of the medicinal plant, which is useful for that. I have to make the composition in the form of lotion, powder, or syrup, and I have to apply for that. And we have to do the clinical trials. Really, if you are doing, you can find the solution for that. We know Vatica in the market, Dove shampoo in the market, Clinic Plus in the market. Many shampoos are in the market, but if you are developing herbal dandruff curing composition from your plants, then that is an again herbal shampoo. You can go for the patenting. Another example I'll take you. During the puja of our Dashara, we bring our Ganesha, we bring many flowers, garlands, tulsi, grasses, different kinds, flowers, and we make the puja of 9 or 11 days. After that, we throw in some ponds, river, or lakes. What we are doing, we are polluting the aquatic life that is ultimately affecting the aquatic life of the pond or river. If you are giving biological method for treatment of pond or river water, solution to the problem. Biological method will not cause any harmness to the aquatic life. Again, this thing. Or production of methane, production of biodiesel. How simple problems are there? You can solve the problem. For many agricultural products are now, you can use herbicides, you can biological method for controlling the pesticides or insecticides. Many are there. We are supposed to do and we have to work accordingly. Definitely you can apply for the patent and you can get a patent for us and you can become an inventor. Let us see what is patentable in India. Every country is having different law. USA is having different law. We are having different law. EP is having, China is having different law. Depend upon country to country. In India, all processes and products are patentable. Product includes apparatus, device, machines, medicines, chemical products. Process means any process. Process of cleaning, process of production, process of preparing, all the processes are patentable. And those processes should be new and those should be qualify the definition of inventive step. Again, they should be industrially applicable. And some sections are there, that is section 3 and 4, which is called as non-patentable inventions. India is not giving patent for those. Please check the section 3 and 4, like method of treatment, plant as such, animal as such, atomic energy elements, even the presentation of information, traditional knowledge are not patentable still in India. When we can say the research or the project, what you did is new. When your research work should not be published in India or elsewhere. Again, it should not be in the prior public knowledge or prior public use within India. Or it should not be claimed before in any specific in India or elsewhere. Then your technology, your method, your process, your composition, what you have developed is a new, we can say it is fulfilling the requirement of novelty to get a patent. Again, it should fulfill the requirement of inventive step. Now, what is inventive step? Inventive step means feature of invention that involves technical advancement as compared to the existing knowledge. I'll give an example for this first para. Technical advancement, as I told you, Alexander Graham Bell telephone to mobile phone. What is this? Technical advancement. We from this to we gone that. Another example is I told you paracetamol. One paracetamol which I can reduce fever within 8 hours, another paracetamol within 3 hours. That's again technologically we gone advancement. Or it should have economic significance. Again, what is the economic significance? As I told you, in the year 2000, when simple Nokia phone which came were around more than 5,000 rupees. Now even 1,000, 2,000, 5,000, 40,000 we are having. That's an economic significance. Or both. It should qualify both. And that make invention not obvious to a person's skill in that. No, what is obviousness and what is person's skill in that? For example, if I'm filing the invention related to herbal composition, then the person of the pharma or botany or biotechnology is a person skill in the art, having the general knowledge about the field of that invention. If I'm speaking about the fridge, then the person who is having the electronic engineering knowledge is a person is a skill in that. But what is obviousness? For example, if I'm preparing a tea, we know the process of making a tea. Taking a cup of water, allowing it to boil, adding cup of milk, allow it to boil, then adding pinch of tea powder or sugar as per the taste. And one of the ingredients to enhance the taste is an ginger. But if you are going to Gujarat, if that follows our same process, but they are adding for the tasting it as an cardamom, that is elaichi. And if you are coming towards the Maharashtra, Same steps, but for the enhancement of the taste, they are adding roots of some medicinal plants. That is in Marathi called or that leaves of medicinal plants. So these are different states using different components to enhance the taste of that. If somebody is from Andhra Pradesh is visiting to Karnataka, Gujarat, and Maharashtra, he is tasting all the three needs tea. Even in his own state, after going back, he can prepare the tea by using ginger or cardamom or roots of some medicinal plants. This is an very obvious to him to prepare the tea. But in getting the patent, it should not be obvious to the person. Therefore, then only they can fulfill the requirement of inventive step. It means you want to do some experiments. Easily we cannot arrive at the composition of dandruff. You have to do some practical work. Then only you'll arrive. So to any invention, it should not be obvious to a person's skill in art. Then we can say you are fulfilling the requirement of inventive step to get the patent. Now, how, for example, surprising result. If I am mixing three medicinal plants and getting the result A, B, C is something 70, but combining this, if I am getting more than 90, that's a surprise result. During corona, we heard you should drink kada. What is that kada? Extract of some medicinal plants or extract of some spices. If that kada is giving something surprising, that's again invention. But no one did that. Solution to a long-standing problem. Since by long we were needed solar system to convert solar energy to electrical, but no one has found. Now we are getting fulfilled of a long felt need. Since long back we are needed many things, but no one got. Great technical progress like Covaxin, Covishield. Within 1 year we got. That's a great technique. If you are doing something like this, surprising or solving some problems, definitely you can get patent for that. Again, another requirement is it should be capable of industrial use or it should be made in the industry. There are some sections which are not necessary to say here because I'm going to the basics of this. I'll take one example. For example, you are botany fellow. So you are preparing herbicidal composition and method of using naturally occurring organic compound as an herbicide. So this and somebody has done the invention, they filed the patent for that. So you can also do any composition with your medicinal plants. If you are chemistry, go in the chemistry composition, like chemical composition for treatment of so and so disease. If you are herbal, go for the herbal techniques. He has done the present invention is generally listed an herbicidal composition, method of using as a naturally occurring plant-derived organic compound as an herbicide. He is isolating some compound from the medicinal plants and using as an herbicide with some expense. This is an invention. If you are also doing such type of use any kind of, and that can be patentable. Now, I'll tell you another example. I'll take you. Yeah, and that herbicidal composition, how he's using, that's first claim means how he is making his composition, how he is using. Method of controlling unwanted plants, the method comprising providing an herbicidal composition, the herbicidal composition comprising naturally occurring plant-derived organic compound, naturally occurring plant-derived organic compound being less toxic than the common table salt, applying the herbicidal composition to the unwanted plants and applying a fertilizer to the unwanted plants prior to doing this after the application of the herbicidal composition. Means how he is using his composition as an controlling the unwanted plants he is doing. So this is one of the method for doing this. Second claim. If you are isolating some compounds or synthesizing some compound, then you can claim as a compound of formula so and so, wherein R1 is something, R2 is something, X is an oxygen, what is that, N is what, R1, R2 what, all we have to disclose if you are claiming the compound as such. If you are claiming the process, if you are developing any process of preparation of trifluoromethane sulfonic ester of ethyl R2 hydroxy 4-phenyl butyrate, it's a chemical process. If you are developing your herbal process, a process of preparation of biodiesel comprising steps of selecting the medicinal plants, what you are doing, crushing, then cutting, drying, whatever steps you have to disclose all. It is called claiming the application. If you are claiming the composition, again, pharmaceutical composition, which comprises acetic salt, salt compound, and salt thereof. So all this we have to claim in this fashion. Composition as claim is an aqueous suspension solution. As I told you, dandruff curing composition. What form it has to be? How you are using? He is doing for ointment, eye drop, nasal drop. You can write for dandruff. Then again, which form? He is telling you insufficient powder form. So any form, which form you are developing your product, you can mention that. So all the forms you can take, lotion, liquid form, any form you can take if you are having the compositions. Let us see, you have learned by this time what are different intellectual property rights, how to do your new invention, what topics you have to select, and how to write also. Now, how to file the patent applications in India, because only 15 minutes are left out. I have trust. Who can file now? Any person, natural, startup, company, anyone can file the patent application. There is no age bar limit because invention can done by any person, any age. There is no age bar limit. Therefore, you can file the patent. Many patents you can see in the Google. The students of 8th and 9th has invented very good ideas. One of the fellow from South India has increased the life of the banana leaves, which can stay more than 1 year, it seems. One of the Nagpur fellow who is a 14-year-old, he has developed an electronic device which can intimate you that you are getting the heart attack. So many other students are doing good research. How to file the patent application? Physically, you can go to the patent office, you can file, or by sitting in your own office or home, you can file, because since July 20, we have given the option to file online also. There are different jurisdictions. As you are from South, Chennai is your jurisdiction. Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Union Territories of Pondicherry and Lakshadweep, newly formed state Telangana also. So depend upon the jurisdiction, you are supposed to file your application. What are the documents minimum required to file the patent application? As covering letters, as usually we need for every application. Form 1 is required to state detail about the applicant detail, name, address, type of application, all you have to mention in the form 1. In that column 9, that is, you have to sign by the all the inventors, means who are directly indirectly helping to carry out the research. Again, form 2 is required to state that you are filing provisional application or complete application. Now, what is provisional? Provisional means as soon as the idea get in mind, you are writing on some piece of paper, you are filing, that is called provisional application. Now, I'm getting the idea today by sitting in my lab. I should develop herbal composition for the psoriasis, because the persons who are working in the paddy field are always in the water and they are having some skin problems, that is psoriasis type. So I am developing herbal composition for psoriasis. I got idea, but how I am doing, what plants I am selecting, all I have to write 2 or 3 pages. I have to file, that is called provisional application. Complete means by completing all your research work, lab works, clinical trials, finally with the claims what you want protection that you are filing, that is called complete application. Form 3 is required to state that whether you are filing the same invention in foreign countries or not. If you are filing in the foreign countries, then you have to mention which country you are filing, name of the country, date, and what is the status of that application in that country you have to mention. Form 5 is for the declaration of inventorship. It means whenever you are publish our papers, we add myself as a first author and my lab mate as second, third author. Same way, if you want to add your friend's name, you can use Form 5 to add their name. But keep in mind that in paper publication, first author is having more value. Here, everyone is having equal value. If you are developing any shampoos, any herbal medicine, and you are going for the commercialization, then you have to share equal benefit to your partners. Therefore, think really who are helping you directly, their name you can add. Otherwise, unnecessary name you don't add. Form 18 is for the request for examination. Until unless you request for the examination, we never examine your application. Therefore, it's necessary, and within 48 months from the date of filing, you have to request. Drawings, if any, biological material, then where from you took, NBA permission is required for that. A biological sequence, CD form you have to give. Abstract of the invention you have to give. If you are filing physically, check or DD, or if you are filing online, you can pay the online mode of the fees for patent filing. These are the optional. If you want early publication, you can file Form 9. If you are going through agent, Form 26 is required for that. The fees for filing is given in the website. You can check when you're filing, even though 1,600 for the natural person, 8,000 for the others up to 30 pages. More than that, the fees is below. Again, keep in mind that all the teaching institutes are having 80% fee concession. So you are a college teaching institute, you are having 80% fee concession. So you can file more and more patent applications. If you are filing hard copy, it is 10% in addition to the fees what I mentioned in my slides. Form 18 fee is 4,000 for the individual, 20,000 for the other than that. If you are filing Form 9, 2,500 for individual, 12,500 for the company. Again, if you want to get in patent early, very quick, then you are having chance to file expedite examination as per Rule 24B. In that, Form 18A is a must. Filing PCT if India has an international searching authority or international preliminary examination. What is ISA now and what is PCT? PCT means it's in one of the route that is called patent cooperative, wherein single application you can file in the international bureau. You can designate the different countries in and around 153 countries. You can file the patent application. ISA means International Searching Authority. IPA means International Preliminary Exemption Authority. Means once you are filing your invention, we check what is it novel or not. If only search is carried out, ISRA. If report is preparing, IPA. They say that your invention is novel or not, inventive or not. Those are the authorities. Or applicant is a startup, they can request. Or as per 2019 rule, one of the applicant can be ladies, government organization, and institute can also request for the expedite examination. Within 1 year, you can get the patent for that. Fees for Form 18 is 8,000 for the individual, 60,000 for the company. You can get the forms on our website, as I told you. It's a website w.ip.in. If you want to file online patent application, you are supposed to log in ipindiaonline.go.in e-patent filing. Here, digital signature is required or e-signature is required for the patent application, wherein filing the design application, you require a digital signature. For filing trademark, you require a digital signature. But filing and copyright, you don't require any kind of signature. Just log in, create your own ID password, fill the form, upload your work, that may be novel, books, drawings, whatever software, upload, pay the fee online. That's a procedure for filing the copyrights. Now, how we are granting the patent in India? Once you are filing the patent application in India, it's go for the digitization. Then we screen and classify depend upon the subject matter. It is biotechnology, microbiology, electronics, electrical, which field it is. We use the international patent classifying system to classify the patent application. Again, it's very easy for the auto allotment. We are not allotting the files physically to the examiners. We are having auto allotment system. If you are requesting for early publication by paying the more fees, we publish within a week or a month. Otherwise, it takes 18 months for publication. Once it published, anyone can oppose your invention. That is called pre-grant opposition by way of reprint. Anyone can oppose. For example, you are filing dandruff curing composition. So any company who involved in the manufacture of shampoo, they can oppose. No, we know that this plant is already used for curing the dandruff. The process of this making composition or shampoo is known in the market or public domain. This is the proof. Many grounds are there. You can oppose that. And if you are requesting for examination within 48 months, then it's go for the allotment to the examiner and controller. Once it's allotted, examiner search formal, technical, and he give the report to the controller. Control again, he want to add the objection, he can add it, modify it, or delete. Once the report issued to you, that is called first examination report. That is called FER. Once you issue the FER, within 6 months, you are supposed to reply for that. If you are unable to reply, you can take extension of 3 months by filing Form 4 with the prescribed fees. Within 9 months, by hook or crook, you have to reply for the first examination report. If the report is okay, you are meeting all the requirements of our office, then it will be granted. If you are not meeting the requirement of that report, then it will be rejected. If granting or rejecting, you give the speaking order so that you can appeal in the higher courts. Once it's granted, it's go for the publication that is called post-grant publication. Here also, only interested person can oppose the case. Here, anyone, but after the grant, only interested person. Now, who is the person interested? For example, if I'm filing an patent for the Omicron composition, it is granted, then any company who involved in the manufacture of pharma product like Bharat Biotech of Hyderabad, Biocon of Bengaluru, Serum Institute of Pune can oppose the invention because they are involved in the pharmaceutical invention only. If the Maruti Suzuki has done invention in the engine, then Hyundai company, Tata Motors, Mahindra can oppose because the person of the similar field is a person who is an interested person in the field. Then simultaneously we consider opposition board inside the office. They give recommendation on the opposition board. Opponent grounds are forwarded to the applicant. Applicant will give reply on each ground of the opponent. Again, the reply which received from the applicant is forwarded to the opponent. Opponent again give the reply on that. If applicant or opponent requests for the hearing, then we give the opportunity to hear on the particular date like a court hearing. They come to us across the table. They discuss each ground of the opponent. If applicant is able to overcome all the grounds of opponent, then it will be granted. If applicant fails to overcome all any of the ground of opponent, it will be rejected. If you are granting or rejecting, we give the speaking order so that they can appeal in the again higher courts. If you are granting, same day we issue the certificate of grant. What is the role of patent system? Increasement or improvement of technology. Earlier we are not having RT-PCR, now we got. Earlier we are not having CT scan machine, we got. Many improvement in the technology. Providing reward as an exclusive right for disclosure. If you are doing something, government is giving patent as a reward for you. Making profit or earning royalty through putting the invention in practice. Many teaching faculty take the patent to namesake to get a principalship or professorship, but let it work and get it benefit to everyone. Transferring into public property after expiry of term. After 20 years, no one can keep with them. It's in public domain. If you are getting the patent and if you are unable to pay the renewal fees, it will be seized. Then anyone can use your patent application. What to do now? You came to know different kind of intellectual property, how to write that, how to think about that. Again, what are the important of that and how to file also. Now, don't keep quiet. Share the benefit of patent system in school, colleges, universities, even campus or in the public also, or wherever you get the opportunity to share your knowledge, you can share it out. Utilize the resource through organized R&D activities. Capture the global market judicially. If you are doing something new, design or patent, don't come in the market. First protect, then come in the market. Earn the profit through the protected market like Samsung, Sony, many companies are in the market. Thank you. Now you can ask any questions with this.
Thank you very much, sir, for an outstanding and insightful presentation. We are truly enlightened with the session, indeed.
Yeah, share the link in the chat box so that everyone fill for that, so that they will get the certificate.
Yes, sir.
By that time, you can ask questions.
Yes, sir. Sir, few questions are there.
Yes, ma'am. You can read it out. I'll answer the questions.
Yes, sir. How does IPR bringing changes in the economy of the nation?
Ma'am, not clearly audible. Where is chat box? Anyone can read? Who can clearly read it out? Or show me chat box. Which chat is chat box, ma'am?
You can see the chat box. Am I audible?
Yes. Now please spell it out.
Yeah. How does IPR help in bringing changes in the economy of the nation?
Very good question, ma'am. Yeah. See, IPR plays very important role in field of chemical, environmental, biotechnological role also. See, you might have heard one of the Supreme Court decision about one of the drug which is for the cancer that is they have filed that Pfizer company as Novartis company has filed the patent application for the one of the drug which was costing 5 times more than what drug at present the people are getting for cancer. So that drug was filed in the country, but our controller of the patent has given rejected. They gone to IPAB. There also they got rejection. They gone to High Court in Chennai. Again rejected. They gone Supreme Court because they are not shown the efficacy of that drug, how much it is important, and their cost. So we have IPR plays here important role. If the IPR would have been not played the important role, this drug would have been got patent by the Novartis company and they have sold in whatever price they want. But government IPR plays important that this that drug was not efficacious, so they are rejected. Now, what is generic drug which are getting all the patients of the cancer are getting benefit of that. Another example I'll give here, tofacitinib is another kind of drug for arthritis. This drug was early one kind of drug was available in the market, even though they have filed mere improved process of the drug and product of the drug. Again, they are costing a lot of more value for a single strip, but again, India has rejected that. So ultimately, I want to say that each product of the medicine in the field of chemistry or pharma, they are lower downing the cost of that medicine, which ultimately affecting the economic of our country. Again, in terms of technology, many technologies are developed by Indians are still playing important role so that the cost of the vehicles, the cost of the particular field are getting lower down. Again, one of the Indian fellow has developed biodiesel and the trial has been done. The flight from Dehradun to Delhi has been flight on the using the same biodiesel. So it's an economically important one. Yes, anyone?
Yes.
Next question, please.
Sir, one more question. One student, Faiza Siddiqui, she has asked, what are the penalties on infringement of intellectual property rights?
Yes, good question. Yeah.
Do they involve complicated court sessions which go on for long, very long?
Yes. Yeah, this see, a patent office work is to up to the grant. After that, who are infringing it is your lookout. For example, if you're having a house, you are keeping boundary of that, and you are the responsible to protect your house. Same way, to protect your patent, we are giving the grant, but who is using that is your work. One of the case from Pune has had same thing. That is a nut bolt company using one particular kind of design of the nut, and he was selling across the South Asia. But one of the company has copied their design and they have started production of that, and they came to know after 5 years. Then they sue them in the court. They have given notice for them. Then he came that person who is manufacturing came to him, apologized him, and whatever the earning he has done, he has seen the seat of annual turnover. From that, he has said the 50% of benefit, and mutually they have got understanding. If you would have not done mutually, it would have gone to court and it should have been years together. Many instrument of court cases are patent, design, especially many are of copyright. Many songs, lyrics, picture of CDs are still going in the infringement of cases. So it's very long process. These are all court proceedings. We have to do initiate all the proceedings of infringement in the court only.
Yes. Thank you, sir. One more question from our student Trupti. She's asking, can you brief us about the examination pattern of patent agents to become patent agents?
Yes, very good, very good. See, we are, I have told you website. Please go there. There is a patent agent examination question paper of previous years. What they ask in the patent agent examination is an Patent Act. It is already in the website. Patent manual already in the website. No need to purchase the book. Just download it out. What is patent? What is patentable in India? What all the sections we have to study in that. So only Patent Act book is sufficient. Another in descriptive pattern, how to handle your client. For example, you are the botany, so you will go to the lawyer or attorney or patent agent. You say, I have developed an medicine of herbal for the cancer. Then how to write that application, how to draft that application, all work is of agent. So such type of questions will be asked in the descriptive. You are the client handling for so and so, he's invented so and so, how will guide him. So all you have to write it practical like lawyer work. Patent agent means nothing but an attorney of that. So please see the questions paper which are there on our website. Accordingly, you can plan, but mainly manual of the Patent Act and the lectures, what is going on in our institute are very much essential. If you are joining continuously within 1 year, you will get qualified for that, because many people are taking use of that and they're writing in comments, sir, we have attended many lectures from your organization, we qualified this year. So last week only the result is announced for the 2022, and exam was conducted in the May of 22. So next year you can apply for that. It's very, and especially it's for ladies, very good job. Only computer and table is required for that, nothing else, because you have to write the application of that, you have to reply the objection of that. Only online communication, only hearing, you have to go sometimes to the office of the patent, or online hearing you can conduct. Okay.
Yes, thank you, sir. One more question. How to access the lectures from your organization?
Yeah, as I told you, we are announcing our website. If you go to our website, you check their RGNIPM. Click on that. There are many already lectures have been announced. But whenever basic lectures, you have to start. Now we are announced physical lecture also, online also. There is already pamphlet are there. One or two examples I'll share with your coordinator. She can share you at what recently we have announced. Same type of announcement will be on our website as well as social media, Facebook. You'll be in check with that. Recently, two announcements are there of July and August. I will share with the coordinator, ma'am.
Yes, sir. Thank you. One more question, sir. Our student Deeksha Mallikarjun, she is asking, the getting patent, different companies are getting benefited from the patent, and this is just creating discrimination among poor and rich. So how we can that will be helpful to bifurcate the social needs of the individuals.
No, in getting patent, how we can discriminate poor and rich? Anyway, can even there are many persons who are working in the bamboo growing areas. They are also developing new inventions. One of the fellows developed new design by using the bamboo sticks.
So
So it is
especially
not
for the drugs,
drugs. Okay.
especially for the essential drugs.
Yeah. So getting the patent for any drug, we are not discriminating. Drug is not discriminating to poor and rich. They cost, because once they are manufacturing a drug which got the patent by particularly, they decide the price of that. So how we are discriminating? We are not discriminating like that. The patent will not be, we cannot say that patent, by getting the patent, that company is discriminating by lower fellows and higher fellows like that, because patent is for all. It is valid for all company, and the price is same. If you go to poor fellow, go to the pharma, or somebody go to pharmacist, it is the price is same for that. So you cannot say like that.
All right, sir. Thank you very much, sir, for your response. And the students, I hope all of you got benefited with the answers. Now, thank you very much, all the participants, for your precious time to join our workshop. Now, I would like to call Dr. N.C. David to give formal vote of thanks on behalf of the Department of Botany and the Jyoti Nivas College Management.
Before that, one announcement. Dear participant, don't forget to fill the feedback link. And after, if you're not filling the feedback link, and don't ask your coordinator that certificate has not been got. So please promptly fill the link. Then coordinator will not be responsible for that. We are, if you're filling, then you are getting the certificate. Otherwise, you will not get the certificate. Okay.
Good afternoon. As a common saying goes, knowing what to do with time is the key to bring productivity. Had a very productive and informative session so far. The topic discussed today is very apt and more relevant, as most of our innovation and techniques go without copyrights. Today's presentation has thrown light on innovation, design, and their patents. My sincere thanks to our resource person, Dr. Bharat. I thank our beloved principal, Dr. Sister Lalita Thomas, for her constant support and guidance. I thank our management, our vice principal, chief coordinator of sciences, Dr. Seethavi Ethendran, for her valuable inputs. I thank our college technical staff, Mr. Praveen, and non-teaching staff for their kind cooperation. I especially thank our all participants for their active participation and well-being. Kindly note, participants, you are requested to submit the feedback form sent to your registered mail ID, or the feedback form link will be shared in the chat box. Thanks, one and all. God bless.